Do you believe your non-disclosure agreement will actually protect you against someone trying to steal your idea? Well, guess what? It might not. In fact, if you don't do a few very important things, your non-disclosure agreement could be utterly useless or even counterproductive. In this video, I'm going to explain how to make those agreements effective and practically ironclad. Stick around to the end because I'm going to tell you about a trick a lot of companies use to defeat their secrecy obligations and potentially defeat your rights. Also, check out the description of this video for a link to a free online course on writing your own custom NDA or confidentiality agreement. Okay, let's get started. As you probably know, a non-disclosure agreement, also called an NDA, is a contract between you and at least one other person, which is designed to safeguard the secrecy of what you tell that person about your idea. They are sometimes called confidentiality agreements or secrecy agreements, but whatever you call them, they are a written contract signed by you and the other person that protects your ideas and protects your confidential information. Like any contract, they have certain weak points which, if exploited, can result in the loss of your rights. In this video, I'm going to talk about how to avoid some very common mistakes which I see. So NDA agreements, like any agreement, have certain weak points which, if you're not careful with, can result in the loss of your rights. So let's go through these weak points and how you can avoid falling into a trap. Firstly, the agreement should be entirely in writing. While it's not impossible to have a valid, non-written confidentiality agreement or NDA, they can be very, very difficult to enforce. More importantly, if important terms are not included in the body of the agreement, you can be prevented from arguing that additional terms and conditions which were verbally agreed to by the parties are part of the agreement. The written agreement should contain all of the terms you require to protect your rights. So you have to have a written agreement to ensure that that agreement meets your needs. Also, it must be signed by all of the parties. This should be obvious, but it's amazing how often I come across people trying to rely on an unsigned or partially signed NDA. Those things just aren't enforceable. If they're not signed, they're not enforceable. It's just that simple. This is particularly true if the NDA agreement is between several different parties. The parties that don't sign the agreement are not bound by the terms of the agreement. You have to make sure the agreement is signed, and it has to be signed by everyone who's a party to the agreement. The agreement must correctly name the parties. This is probably the biggest defect I've seen in various faulty NDA agreements. So let's take a bit of time here in this video to discuss this topic a little bit more thoroughly. Again, check the written description for additional information and a link to a free online course on NDAs, which goes into this topic with more detail. First of all, name all the parties. If the NDA is between you and another party, let's say Mr. X, then the agreement does not apply to any other party, say Mr. Y, who is not a named party to the agreement. If you have a meeting between yourself and Mr. X and Mr. Y is also in that meeting, then only Mr. X will have a duty to keep the information secret. Mr. Y is free to use the information as they want. There's one exception, and that relates to employees, which we're going to discuss a little later. But as a general principle, in order to protect yourself, each person receiving the confidential information must be named as a party and also sign the agreement. Now, the first part of the agreement recites the full legal names of the parties who are going to be part of the agreement. Each party must be properly named and listed in this part of the agreement. It goes without saying that you should get their correct spelling and their full legal name. The name of the party is important. To avoid difficulties, the full legal name of each party should be listed. So don't use nicknames or any other name other than the proper legal name of each party. Double check the names by checking their driver's license or other identification to make sure that you have the spelling right. If you're dealing with corporations, then make sure that you've identified the company correctly. Now be careful here. Different companies can have very similar sounding names. Firstly, make sure that you have the correct corporate identifier. Now, generally there will be a series of letters which identify a business as being a limited liability company, such as Inc., Ltd., LLC, Incorporated, Limited, things like that. There are many different corporate identifiers which are used to indicate that the business is a limited liability company. For example, ABC Manufacturing Inc. is not the same company as ABC Manufacturing LLC or ABC Manufacturing Incorporated. These may be related companies, but they are not the same company, and only the one named in the agreement is made a party of that agreement. In the description of this video, I include a list of the types of various corporate identifiers which are commonly used in basically North America, Europe, and so forth. So check that out. The agreement must identify the confidential information which is going to be protected. Generally, there will be a clause in the agreement which defines the information which is going to be confidential. The information is usually given a general all-purpose name such as, quote, information relating to X, end quote, where X is the subject matter of the information. So if you're going to be talking about electric toothbrushes, that information will be generally called information relating to electric toothbrushes, something like that. See examples in the description of this video. There will also be a clause which states that the confidential information includes things such as drawings, verbal conversations, emails, text messages, videos, electronic files, charts, tables, and any other type of written or electronic information. Now this next point is all important. The agreement has to have a clause which puts an active duty on the parties receiving the confidential information not to disclose the information to anyone who's not a party to that agreement. Ideally, the clause should specify that the receiving party will use their best efforts to keep the confidential information secure and guard it against being accessed by anyone who's not a party to the agreement. Now, here's another huge issue with NDAs which I've seen over the years, which relates to basically the treatment of employees and independent contractors. The agreement should specify that any of the parties' employees must adhere to the terms of the confidentiality agreement and must keep the confidential information secret. In many legal jurisdictions, this obligation happens almost automatically. However, independent contractors are usually exempt from these obligations. Independent contractors are not employees, and they are generally not bound by the terms of the NDA agreement unless the NDA agreement specifically names the independent contractor as a named party to the agreement. Therefore, make sure that everyone attending the meeting or otherwise receiving the information is either an employee of the parties or a named party themselves. Now, the agreement must contain a clause that specifies that the party receiving the confidential information obtains no rights to use or any license to the confidential information. The clause should confirm that you retain ownership of the confidential information and that any intellectual property rights contained therein belong to you. There really should not be any exceptions to this general principle. Okay, so now let's talk about that one trick companies often use to circumvent any obligation of confidentiality should they talk with you about your confidential information. I'm talking about a non-confidentiality agreement. This is a written agreement where you agree that any information you tell the company is not confidential and that the company is not obligated to keep that information secret. Companies, including some well-known tech companies, will often require you to sign such an agreement before they enter into any discussions with you concerning your confidential information. It should be obvious that you should not sign that type of agreement. Don't be fooled if the agreement has the title like Confidential Information Agreement or a Disclosure Agreement or something like that. You have to read that agreement carefully to ensure that the agreement you're being asked to sign doesn't deprive you of your rights to keep your confidential information confidential. And never under any circumstances should you sign an agreement that you don't fully understand. So that's NDA agreements in a nutshell. As I said, there's a link in the description to this video for a free online course on how to draft your own NDA agreements, so check that out. If you have any comments on this video, if you have any topics or suggestions for things you'd like me to discuss, leave me a comment below and I'll see if I can help you out. Thank you very much, everyone.